Welcome, everybody. My name is Vicky Hanna, and I'm going to be your trainer and deliver this unit, which is CHCLEG001, Work Legally and Ethically. This is a core unit in Community Services Qualifications. So before we commence, let me do acknowledgement to country. In the spirit of reconciliation, Hayter Institute of Education acknowledges the traditional custodians of country throughout Australia and their connection to land, sea and community. We recognise Aboriginal and Torres Strait Islander people as the first inhabitants of this nation and the traditional custodians of the land on which we work, live and study. We express our gratitude for the sharing of this land, our sorrow for the personal, spiritual and cultural costs of that sharing, and hope that we may move forward together in harmony and in the spirit of healing. We pay our respect to all First Nation people and acknowledge elders past, present and emerging. And I would like to extend this out to anyone who is First Nation or Torres Strait Islander who will be watching this recording. So let's begin. So as a key unit in the community service sector, know that you are legally and ethically responsible to carry out your services and practice standards within the law and within the guidelines of your organisation. We'll cover more on that soon. I'm going to break this unit down into three pieces. I'm going to do these sessions because it can be pretty hard going. I want you to take some of those study breaks. We know that 45 minutes is the perfect amount of time for people to be able to focus on something and retain that information and then be able to take a 5-minute break and come back in again. So there's a lot of content in the slides that I give you. There's great information in your learner's guide. And inside these slides is also some additional video recordings, which I want you to be able to watch. So you'll get key learnings from the resources that we provide you. And you're also going to be doing a little bit of research. What does that mean in your state or territory where you live? We'll focus around what's inside the simulated workplace environment for you with First Access, which we give you to get all your templates and your policies and procedures, how to navigate that space for yourself, do some research of your own, making sure that it is evidence-based, and when you're supporting it. You have written assessments here, and you also have skills assessment. So because we are an online training organisation for the convenience of people who can't always have a college close to them, or people who are needing to be able to do things and work from home, that's how we present our courses to you. But we also provide, along with this recording on this unit for you, a study session, one on the content, and also another study session on the assessments, and we'll make both of those available. So 50% of your qualification in this unit will be written, and then the remaining 50% will be skills, which will be done in role plays, and they'll be recorded. And this is for you to be able to read the instructions, follow those guidelines, and be able to apply that knowledge that you've learned over into your skills assessment. So both will be assessed. Your understanding, that underpinning knowledge that you've gathered while you've been studying this unit, and then also your ability to be able to do that in a simulated environment with a client or someone who will play the client for you. So some role plays are based with real time with a trainer and assessor. Each unit will tell you the instructions for that. So there are 2 role plays for this one. There's also other written assessment where there's quite a lot of case work. So we give you stories. How would you apply both the legal and ethical? You will need to do task 1, and that will lead into task 2 Task 3 and Task 4. Start there. That gives you the beginning and the entry. You will have an opportunity to do e-learning, and e-learning is practice run, and while it doesn't apply to your assessment, it gets you used to the language. You don't have to do them. They don't count towards your assessment. However, for some people, if you want to be familiar in this space, you can try those e-learnings. But over in assessment in your student portal, where learners go, assessment is where you're going to be marking. So you can start your assessment, you can hit save, and then come back to that when you've got more time. So do that progressively. It takes about 10 to 12 hours to complete one full unit. And that is something for us to be able to do. Then you've got your role play assessments on top of that. So that comprises of watching videos, watching this recording, going through your learner's guide. I encourage you, some good study practices are to give yourself focus time, and then rather than say, I'm going to leave it till the end and I'm going to smash it all out over a weekend, know that you may not be picking up some of the other learning. So learning builds on learning, and it's layer by layer. So you're best to have those breaks if you can, but how you study is entirely up to you. Just make sure that you've got a study plan and that you're structured with that. The legal and the ethical framework is extremely important. So in the sector, I am a court officer and a court-appointed advocate. So I work in this space primarily around the most vulnerable members of the community. So the legal and ethical framework, ethical means you may have a dilemma where you know what you must do, but you're really struggling because you've got a bit more information and circumstances. You will be guided by what your position description says you can do, what your policies and procedures say you must do, and then, of course, the legislation, the law, which overrides everything. So when we're working in an organisation, our policies and procedures and our position description cannot be in conflict with the law. So we need to make sure that we're current and that we have a good understanding around what frames, which law, which legislation applies to the work that you're going to do. Let's unpack some of that together. So by the end of session 3, and I'll break it down into 3 smaller parts for you, you'll have a better understanding of what the sources of legal and ethical information applies to your role. There is information here around NDIS, which is the National Disability Insurance Scheme, governed by NDIA. And so from there are the most vulnerable people who need to have individual support applied. So rights and responsibilities of the worker, employers and clients. So who's involved in this relationship, this professional relationship? So it isn't only NDIS, it's any of our clients, but that's definitely an area that of recent times, there's been a Royal Commission around that. They've brought in stricter legal and requirements, tighter controls, and then, of course, the recommendations that came out of the Royal Commission around that. And the report is available for you on the federal government sites, NDIA. So in session 1, we're going to be talking about legal and ethical policies and procedures, codes of conduct and standards. Let me just pop that over there for us. So we have legislation, which is the process of making or enacting the laws. So we must work within the legislation. Industry standards, that'll depend on the role that you do in the community sector, which these qualifications are recognised for. These are Australian quality standards. And so that means wherever you are in Australia, This unit, when you pass this and have competency and you can use this towards other studies, this will mean that you meet the Australian quality standards and framework around this accreditation. So the standards are usually set by peak industry bodies and sector bodies. I'm based in Queensland, so some of the peak bodies that I work under are Queensland Alliance of Mental Health, Q Shelter, the Mental Health Commissioner. You've got laws, you've got your privacy laws, 1988, that legislation. You've got the NDIA, and then you've got all of the others, pieces of legislation that sit inside of that. Now, they are updated regularly, so you need to make sure, and it is our responsibility, that we stay current in the code of conduct. It's set by the organisation that you work for. So you have that relationship as an employee or a volunteer with that employer. Those are set in keeping with the legislation. So they cannot be in conflict. So the employees must conduct themselves in their role according to the codes, those guidelines, your policies, procedures, the protocols that sit around that. You will find all of those in the simulated workplace environment under First Access. When you open up your assessments, you will have links inside there where it's got all of the policies and procedures and quite a lot of information. This particular unit, though, has got also some tips in here for your written assessment and your casework. So these slides here are a great resource for you as well. We've done some of that research, and then you, of course, will do some of your own. And then, of course, we have the policies and procedures, which says what we will do and how we will do that. And this will include, say, for example, your mandatory reporting procedures or your incident reports. Okay. So where do we get our sources of legal information? So our policies and procedures, the code of conduct, which will be written, Fair Work Australia's information statement. So if you go in and have a look at the particular award, so the award for most workers in the community sector is SHADS, SCHADS, which is Social and Community Housing and Disability. So the awards go from level 1 through to level 7, and level 1 would be 1.1, 1.2, 1.3, and so forth, all the way up, which means that it's very clear on what your pay rate says that you will be able to do and what your position description needs to match that as well. So from time to time, you'll be asked to do other duties. You may even be asked to step up a little into someone else's role, and that can happen, and there are opportunities, but you cannot be expected to be working outside of the agreement that you have in place. Now, that is your legal right. That's your legal right between you and your employer. So there's that professional relationship. And then the employer has the right and the responsibility to make sure that they provide a safe environment for you to work and the resources to be able to undertake that role. So while you may be an experienced worker, and this is a new qualification for you, from one organisation to another, those policies and procedures can change. That depends on the model of service that they're there to deliver. So that changes from organisation to organisation, and we need to be familiar. It can often be part of our onboarding, our induction into a new role, but it also should be ongoing, improving performance, refer to policies and procedures, which I really like, because I like to know if I'm getting something right. So I like to refer back to that. I write them, and then when I'm working with staff, I deliver these as ongoing information, education, and raising awareness. So something we find, and this happens a couple of times a year when you've got a change of staff, that it might be time to refresh those policies and procedures. And Fair Work Australia may change the award. and put different expectations in there. So your employment contract and any of the extras that go inside there, the awards or any enterprise agreement, a common one in the community sector is the SHADS award. You'll find that on Fair Work's site. Human resource management of staff, again, that's Fair Work, will give you guidance around that. Or you might have a union and your union membership would give you that information as well. And then ongoing professional development. So that can happen internally. Your organisation might say, oh, we've got a training and development day, or we've got guest speakers coming in, or we want to form a safety and respect committee, and they might invite you into some of those things as well. This is how your employer gets to see you in action, your peers get to see you in action, and then also your organisation can recognise the knowledge and skills that you have got. HR will often want to know if you've done an extra bit of training, then we should be updating that information as well into our HR file. And then, of course, any professional development that you do, share that so that HR can put that into it. But it keeps you current. And a lot of sector workers must remain current. And in that, it would be, we will do professional development 2 or 3 times a year. Sometimes your employer will provide that. However, it's ongoing. As a worker, regardless of the program that we're in and the employer that we're working for, we have a responsibility to make sure that we keep up to date with the legislation and our professional skills. Let's have a look at the sources of legal information. So Commonwealth law is federal. So we have, and this will be in your assessment, there's some links here in your slides. If you find that a link doesn't take you directly to a site, just take the keywords and put it into your own search engine. In September 2024, there was quite a lot of cybersecurity activity going on. So it could simply be that something in your learner's guide or something on a slide, they'll view that as a third party trying to access, and you may not be able to go directly in because of the things that you have sitting in your device, your phone or your laptop or your tablet. So make sure that you take the keywords and put those into that site around with the information that you're looking for, and it'll let you in directly. So Fair Work Ombudsman, remember this is part of your assessment. Australian Human Rights Commission, they set up a tribunal. The Attorney General's Department, also human rights. Job access, and that changes any of the employment services, disability and other. Office of the Australian Information Commissioner, which is around privacy information. These are the federal laws. Department of Health, look at disability services, especially when we're looking at NDIS. And then the Department of Veteran Affairs for services for veterans. So it depends on the work that you're going to be doing. All of these are relevant. Sometimes when we're working with clients, they could be concerned about a member of their family. And while that may not be present for your client directly, indirectly, the people they care about, it may be. So you can help your clients. You don't need to know it word for word, but it is good to know how to find that information because it could be for your client and some of the support that you provide them. You'll be asked these questions in your written work. In the Fair Work Commission, you go to that site, it's the Fair Work Act of 2009. Prior to that, there were a lot of different state awards and territory awards and different enterprise bargaining. In 2009, the Prime Minister of the day happened to have been Julia Gillard. And Julia Gillard streamlined a lot of all those different awards so that a worker who went from one state to another state or a territory, that the laws would change, and it made it very difficult. This happens a lot in trades, but your qualification is a national qualification. Once you've got this unit or other units, then that is an Australian quality standard. That's recognised. That's across every state or territory. You should be able to work in different places with different clients and know that your qualification will meet that. So the Fair Work Commission did the same with salaries and wages. So enterprise bargaining still applies. However, it's a consultative process with employees, the workers. If you have an enterprise bargaining agreement, it cannot be less than the award. It might have some variations, but it cannot be less than. That is the minimum requirement. So you may get more because they need to have an enterprise bargaining to have some flexibility to meet some of the hours. So in the sectors that I work in, outside of when I'm training, we work 24/7 and we have on call. So we have fatigue management, which is under workplace health and safety. So to do that, we need to have different awards look after us or an enterprise bargaining agreement that allows for flexibility in that space as well. So you have your national employment standards, and there are 10 national employment standards. You have your modern awards being 2009 and any updates. And then the national minimum wage orders, which means no matter what, you should have the minimum wage. And then it takes you to Fair Work Australia site, which of course you can go in there. It's a lot of great information. You will need that with some of your work. So what is the Fair Work Act? There's a video there for you to watch in your own time. So the privacy, confidentiality and disclosure statement sits around our award. Anyone that is working in the sector needs to be aware of the privacy and confidentiality that we must have when we're working with our clients. There needs to be trust. They need to be able to have that connection with us and know that we will look after their conversation. We won't repeat that. We won't represent them without their consent. And we will store their information safely. And we are guardians of that information. We can only use it within the scope of the role according to the guidelines that we have at work and also according to the law. So there'll be personal information we need to safeguard. That's going to build the confidence, the trust. A breach can be, especially if it's with intent, can actually end up in the criminal court if it's caused any harm. That our clients have rights, and you, of course, too, have rights. And your employer has rights, and everybody has responsibilities. So remedies for any privacy breaches, we could have recommendations, but it could also mean that it's a civil matter and it can impact negatively your reputation. It can also damage the reputation of the organisation or have an adverse effect on somebody else's reputation, your clients. So if you've got justified disclosure, that usually sits around mandatory reporting and that is covered, but intention is extremely important here. If it was an oversight or an error and the best of intentions were there and you can prove that, then it'll usually satisfy that. It does not mean that an apology won't be required. And it also does not mean that, especially if it's Human Rights Commission, that penalties, financial penalties may not apply. So in your state or territory, have a look at the privacy and health record around keeping that privacy. So in the ACT, it's referred to as Information Privacy Commissioner. Somewhere different. I'm in Queensland, so for me, it's Queensland Office of the Information Commissioner. You might be where Hayter are located, where we're looking at the Office of the Victorian Information Commissioner, which is our head office. But every state or territory has their own. You'll need to refer to these as well in your role, wherever you are working or wherever your clients are based. Those two things may be different as well. We have the privacy principles that we must conduct ourselves with. How we collect information, how we access it and store that securely, how we use it. What are the identifiers? We might have a Centrelink number, or we might have a client number rather than put a client's name. How we look after our data, making sure that it's factual, and our record management is not our opinion and it's not a narrative, that it's fact-based. So we might frame a client's conversation with the client stated, rather than the client has depression. The client stated that they experience depression, because we are not clinicians and we do not know. If a GP has provided information and the client consented with that, a diagnosis may be there, but that is not our area of expertise. That is information to be able to help us create the best possible support plan. But we do not diagnose anybody. We are non-clinical workers. This is a non-clinical qualification. What policies and procedures do we have about not having our name and our address? How we seal those documents and that information. So what is our data security? What happens from border to border, territory to territory? How open and transparent are we in the organisation I work with in the sector? We believe, and it's part of our value space, is that the file that we keep on a client, where all of our record and progressive file notes go, that file belongs to the client. So the client should be able to read that anytime they request. And so therefore we would have nothing in that file that the client would not agree with, and their interpretation of what our conversations took place, and that it is fact-based. Change in circumstances, we would need to update those files. That could be a change of phone number. Their personal circumstances could change, change of address, and we need to check that information and keep that secure. If somebody calls and says, I understand you're working with Mary, you can't say if you are working with Mary. You say, look, I'm unable to provide you with anybody's private and confidential information. If you were hoping to speak to somebody, perhaps you could talk to them directly. And of course, if they are a client, we would need their permission to discuss that. And they would give us authority on who we could do that with. So it's not our role to share information unless our client has said, here is someone I authorise you to do that. So in your intake and assessment, they may not have mentioned that person, but if from time to time you're reviewing your client's file, you might say, is there anybody I would call in case of an emergency for you? And often that is called next of kin, but kin doesn't necessarily mean family or legal guardian. It could be somebody that's significant to you, significant to the client in their lives, and they would give consent for us to do that. So informed consent means, what are you going to do with that information? What would you tell them about me? Just signing a consent form does not give you free range. Most of them have a sunset clause. So for the purpose of this referral, and then this will, by the end of November, and then we would need to update that again. Just because you've got it on a client's file does not mean forever and a day. You need to continually check if the client gives consent, because those relationships can break down. We can change a doctor, we can change our service providers, we can change a phone number, and we can change address. So informed consent, that will be a video. There's quite a few videos in here for you to be able to get your resources and information. There is different guidelines around just people who are vulnerable, people with differing abilities, and you need to be aware of that. That'll sit mostly around NDIS, so I encourage you to go to NDIA and the Human Rights Commission. Child safety as well. In the Human Rights Commission site is actually the worker orientation onboarding sheet. So there is self-paced free. session that you can do online. It takes about 1.5 hours to complete it. You log in, you can stop and start and save your work and then go back in. And when you have done that, the orientation schedule, it will print off for you the certificate that you did that. Now, the law changes. So once every 12 months, we would update that unless you know that there has been a change. So with the NDIS, the Royal Commission, there are hundreds of recommendations. Some of those will be a change in policy and procedure, and people will adopt those recommendations. So just because you learn it does not mean that is it. We need to make sure that we always stay current with our knowledge in those areas. So there's a resource there for you. But in that worker orientation, it's actually put together by members from that target group, which I think is really valuable. It's giving agency and voice to others. So the national standards for disability services are about rights, and there's 6. That's a question, of course, in your assessment. So remember this. It'll ask you, what are they? What are those 6 standards? And so those standards are rights, participation and inclusivity, individual outcomes, self-determination, feedback and complaints, the right to complain if you're not getting the services that are meeting the expectations. And then service access, so being able to access those supports regardless of your race, your religion, your abilities, your level of understanding. Everybody has the right to have access to those services. So we have to approach that and meet our clients' needs where they are, rather than wait for our client to meet our needs where we are, or our understanding there. And our service management, which is often our service model. So for the case of you in a simulated workplace environment, first access in your staff logging portal, when you go into your Learner's Guide, it will give you that information on how to get into first access once you start your assessments. So go in and have a look at the organisation. It's simulated, but it's very similar to a lot of other dashboards. So I've worked with lots of different organisations over the years, and each of them have their own. So even if you are working in the sector and you're studying, your assessments will be around the first access one. Rather than take something from your own organisation, your assessments are mapped to what we have in your assessment tool. So we ask you to use those because they meet that standard for this qualification. You might even go, you know what, I think what I work with is better. For the purpose of this, though, what you're working with that feels right may not meet the Australian Quality Framework, and you must meet that national standard. We've done that for you ahead of time with your resources. So use them, even if you go, oh, well, I don't know whether I would come across that. You have come across it because it's part of your assessment. So you're not going to do this in groups until you move over into a study session, if you decide you'd like to be one, but we will look at a study session for you on your understanding, your key learnings, and then also another study session around your practical skills and your resources that you're going to use as well. What are the consequences if we don't follow? These are referred to as breach, and it can lead to legal action against you and against the organisation. There can be fines, so penalties, enforceable undertakings. People can lose their funding. People can lose their job. For the person in control, if it's proven that it's intentional, and a worker can be dismissed. If it's a serious case of misconduct, then absolutely you can go before the tribunal and lose your position. If it's unfair, though, if an employer has unfairly put you into that process, then you get your information from Fair Work, from a union representative or Human Rights Commission. When we're doing this unit, it is around legal and ethical. That also means your legal rights and your ethical responsibilities as well. So some of the disability organisations and those links, DSS stands for the Department of Social Services, located in your Centrelink office or Services Australia. So the National Disability Services are a peak body, non-government. So people with disability, First Peoples Disability, National Ethnic Disability Alliance, Women with Disabilities, Children and Young People. The reason why we utilise disability is the most vulnerable members of our community, which of course is where support workers work a lot, may not mean that it's a permanent disability, but for that moment in time, they are able to advocate on their own behalf or to provide those services themselves. So we have a duty of care to deliver those services to our clients and for our clients. So what is that duty of care? It's everyone's obligation to take care, comply, and cooperate. So it's the legal or moral ethical responsibility to protect the safety and well-being of others, which includes taking all reasonable steps not to cause foreseeable harm to another person or their property. And that is where intent comes from. People are human and they have oversights or they may make an error. People have the right to complain and we must record an incident. You'll have policies and procedures to follow. In your First Access site, there will be incident reporting templates. So your duty of care sits around your experience, the training that you get in the workplace, your resources to be able to do your role. And then generally whatever reasonable means is that intention was there. So a group of ordinary people, your peers, would see that as reasonable in a given situation, taking into account all of the information above, your experience. If you're a level entry into the sector, then you wouldn't expect a higher level, nor would you be being paid that higher level. The higher the award rate, the greater the responsibility, and of course the understanding and the qualification would be there. So there's been times where maybe the funding can only allow for a certain award to be paid. Now, I have definitely taken drops in award level based on the program that is there because I want that experience and exposure to it. So to go from a level 6 or a 7 to a level 2 is usually done with a great deal of consideration by that worker. So when I'm applying for a position, because I want access to that target group, and that's the only way I can get it, because where I am and what I'm doing doesn't provide me that anymore. And there's another area I want to have subject matter expertise over, then we make career decisions based on that. You still have all the exact same rights. The things that would be different would be the position description and the award and working to that. So even though I may have higher level skills, I will only do the work that I am contracted to do, which is my employment contract, which I sign and the employer signs. Of course, from time to time, that may have made you the best candidate because you did have that underpinning knowledge or experience. However, 15% is usually that cutoff point. Where it says from time to time, that's usually what's referred to as reasonable. If you were doing it 90% of the time at a much higher level on a much lower wage, that would be viewed as unreasonable. But we can step in for other people, and it depends on where you're working, how they remunerate that. But for me, when I want to go for a position like that, I change my resume to not have it look like I'm overqualified for something, because I really want to be seen as a good candidate for that. And then it's not every tool in my toolkit that I'm going to use. So it may be a less stressful position, but all of them require that I present myself for work and that I am aware of everybody else's rights and responsibilities and my own. So the duty of care depends on the position within the organisation. If you're a supervisor or a team leader, you will have more responsibility. It might be that you left a role and you had a position of authority, but coming in here, if you are just starting, it's unlikely that you would be doing that unless you went for that position exactly and you did that. So you work within the scope of your role and you follow the policies and procedures and guidelines around that for that position description that you're working to. So the person may also owe a duty of care to their colleagues and any visitors who maybe support people around your clients as well. That extends across. Even when we go out in the community and we attend a community event, we are there representing the organisation, and that's our duty of care to make sure that we present ourselves professionally and as a representative of that organisation. So employees' obligations are policies and procedures, workplace health and safety, make sure that we take appropriate action or that we don't leave out information or don't act on something when we know that there's harm to self or others, and to raise concerns about any matter or potential matter that could be a risk to health and safety. So in the duty of care, if you breach it, there is a resulting injury or death to a client or a person in your care, the organisation might be sued if the staff member failed to follow the policies and procedures that you signed when you onboarded, has broken the law and has clearly breached their duty of care. And if an investigation finds that, then that would likely leave you open to losing your suitability to work with young children card or your NDIS card, your clearance in that, because that makes you a fit and proper person to be in the workplace. And that would bring anything you did outside of that, or if you failed in your duty of care, could bring that at risk. It doesn't mean it will, but it could. And so we need to work to those guidelines ourselves. Make sure that you are taking this on board, what it's called in your state or territory, because workplace health and safety is injuries, the physical, the emotional, psychological safety in some states and territories now is actually referred to as workplace health and safety. So when you have children in the workplace, you are responsible. There's no grey in that at all. So the safety of children is a priority, both emotionally and physically. So if young children are visiting a place where there's a lot of vulnerable people there, that could be in a mental health facility. It could be a day respite for alcohol and other drugs. It could be in the correctional centres, in the prisons. If you've got children and you're visiting or you're actually going to another site, you must demonstrate that the children are supervised at all times. You are 100% responsible for that child, nobody else, if you bring that child into that space. So they should occur in a family-friendly environment where children can be. And then also, what is the current state of the parent? Should that be considered before a visit commences? And then consider the child's age and maturity. And then any other parent and staff must be present during the visit, and consideration of others in the facility and their state of mental health. Okay. So in wrapping up that unit, this is about all stakeholders, all the people outside of our client, and then all our shareholders, all the people who are our clients and significant others, our colleagues and our peers. You just step out of here and we'll pause. We'll take a brief break, come back in 5 minutes, and we'll go to session 2. Okay, welcome back. Brief break. We're continuing session 2 of CHCLEG001, Legal and Ethical Frameworks for us as community sector workers. Ethics is values-based. That's the conduct that we do, how we manage ourselves in that space. When we're dealing with our clients, a lot of our work is unsupervised. We're very autonomous in the community sector, and we need to have a certain standard that we all comply with. So you can have a dilemma where your value may be in clash with somebody else's. You might see something happen in the workplace that you're struggling with, need to be able to report that. So right or wrong is not a subjective matter. It's either lawful or it's unlawful. It's either ethical or it's unethical. How do we do our referrals and document our resources? All fact-based. So we use evidence-based resources to be able to justify and do our work. We can't just bring our own ideas into this space. We need to be conducting ourselves with those practices that are adopted, what we refer to as sector practice standards, those benchmarks that we must meet. An organisation will be funded or given a particular role. So I'm a justice of the peace, and I must conduct myself in accordance with being an officer of the court. If I work outside of that, then not only would that be unethical, it would also mean that I may lose that accreditation as well. So it's a legal requirement for me to make sure that I work within the guidelines and that I always stay up to date and I follow those practice standards as well. So by the end of this segment, section 2, we will have covered a bit around human rights and then the needs of our clients, anti-discrimination, complaints and the management of those complaints, codes of practice and practice standards, and codes of conduct and ethics. So your policies and procedures will outline what they are, and the legislation as well. Every legislation has a summary, but your policies and procedures should reflect the law. So your human rights are go to Human Rights Commission and research what the national framework is. Go to your state and territory and research your own state and territory laws, what's required of you. Watch the videos that you've got that come here with the resources for this particular unit. It'll give you some insight and underpinning knowledge. So human rights in the community services and alcohol and other drugs, again, another really vulnerable area of the community. So a person has the right to be presumed as innocent until proven guilty, the right to remain silent, to not give information, the right to be represented by an adult if you are under the age of 18, the right to call a lawyer or gain legal advice, that we are all equal before the law, a right to a hearing on a criminal charge, which is a hearing and a mention and whether that will go forward, the right to practice own cultural values, the right to dignity and respect, the right to be treated without racist bias, the right to be heard and to have a voice, and dignity of risk, the right to make personal choices. That's what human rights are. There's some videos for you to watch here. What's Maslow's hierarchy of need? And what's the Anti-Discrimination Act and the rights and the laws that sit around there? There is no cap to compensation under the Discrimination Act. Out of all of the laws, a lot of them, the compensation might have a cap to the payment, but not under the Disability Act or the Discrimination Act. It depends on how much damage that person has experienced based on somebody breaching those laws. So they're very serious. We can't have our own views and opinions in that place if they are in conflict with the law or the policies and procedures, which also will be inside that law. So watch the videos and the resources to gain some greater understanding. So what's our role in the sector, yours and mine? Be aware of the layering effect of discrimination and disadvantage over a person's lifetime. It may be the final straw. Just because somebody in the workplace says, "Oh, I was only joking," or "Gosh, they always do that," we have no insight over how that person may have experienced that over a lifetime. And because it builds and builds, the harm could be very damaging. So one incident as a standalone may not seem to you be like that. However, for the person on the other end of it or the recipient, that could be the final straw for them. And because these are psychological injuries, they are invisible. We don't always see them and we can't always recognize them and apply mental health first aid like we would if we saw an injury on a physical of first aid. So address direct and indirect discrimination, support people to understand their rights under the discrimination legislation, advocate for the client or support self-advocacy, help them find their own voice, and then refer to human rights or anti-discrimination government bodies to make sure that they are being supported in that space. So unless that is your role, it's in the scope of your role and in your position description, we put wraparound supports, that holistic approach, and we help our clients find out what their rights are and give them the resources to be able to put those in place. Our clients have the right to complain. Step 1 is document the offence. Step 2, disclose to a direct manager confidentially. We're missing step 3. It'll be your incident report. 4, offender advise the opportunity to respond confidentially. Step 5 is a finding is determined. Step 6 is the management to implement the recommendations. And step 7, which is if the complainant is dissatisfied, they can refer it up to a higher body. So step 3 in this would be the incident, whatever the complaint was actually about. The process sits around it. So you have to have a documentation, a policy and a procedure around it. You need to report it. You need to make sure you've got all of that information around the incident, and then you proceed with the rest of the steps, which is the procedures. Refer to your own state and territory anti-discrimination information. These are steps in your assessment, your written assessment, and you'll be required to answer these. The code of practice and the code of conduct as well. Here it's got the conduct of conduct. That means how we apply the code. So how do we apply the code of practice and code of conduct and our conduct when we're implementing that? So the code of practice is the industry standard. The code of conduct is the behaviour and how we conduct ourselves when we're applying that. So it's critical when we're working with vulnerable people in the community. A breach could mean loss of employment or more serious. There's a brief video there for you to watch on what the code of conduct means. So practice standards could be the service model, the standards under the sector that you're working in. So it could be mental health, AOD, child safety, NDIS. So under Mental Health Act, the Mental Health Commissioner of New South Wales would be one, find yours in your own state or territory. The Code of Ethics do some research on the AC, which is the Australian Community Workers Association, on the code of ethics there. Search for that. If your link doesn't take you there directly, then put those keywords into your own search engine. Because of the cybersecurity warning, which is around breach of privacy and confidentiality, sometimes our devices will not give us a direct link, even though the link is fine, because of whatever it is that you watch, or if you're a Facebook watcher or you look at YouTube's, it may flag something bedded in there that is stopping you from being able to access these sites, because these are government sites and the privacy and confidentiality is very stringent in that space. So think about the practice standards, the code of conduct, and the code of ethic. You'll be asked in your casework as part of your assessment, what is it that someone is in breach of with the scenarios that we provide for you. Okay, a brief break. Now we're up to section 3, the final part of this unit, CHCLEG001, work legally and ethically. Okay, looking at the very last part of this unit, work legally and ethically. So our documents and resources need to be factual. We understand that they can be used in court. They can be subpoenaed. So our work that we write has to be accurate. And what the client states, what we saw and what we heard, not what we think. So rarely do people do narrative file notes. We might have more of a narrative if we're doing case management, but that'll happen usually in a template with the headings that we need to have. There's some of our record management systems that we use. We need to make sure that we prepare them as statements of facts. You may actually be asked from time to time to go and speak at court on a report that you have done. You may be witness to something. Keep in mind that this unit is legal and ethical framework. You may be required to give an affidavit to support somebody because of information. When did you find out? And it'll be based on your record management. So make sure that when you are documenting things that you are accurate, you've got the date, exactly what happened, make it really clear, have purpose around it. The best formula for making sure that you've got all of the information into your written file notes is have the who, what, how, when, where, and why. If you can look at your document and go, have I got all of those things in it? And you're satisfied with that, then you'll be able to complete it. It's the same with our incident reports. They usually are a template and they have headings. So when you go into the resources to complete your assessment, then just have a look at the headings that it has. So when it's even an email is a legal document. So your emails are professional. They can be presented in court. They can be used as evidence for or against somebody. So when we're looking at dignity of risk, it's about somebody having the right, even though we might think it's better for them, and this support would be really helpful to resolve an issue that they've presented with. Our clients have dignity of risk that, for example, if someone is smoking and the evidence is there that it's not healthy for people and it could be impacting on their well-being, their health and well-being, it is still up to the client to be making those decisions. Our work as a support worker would be to be able to put things in front of them. What would life look like if you were healthier? What would your finances look like if you weren't investing in cigarettes and you were investing in something else? So the motivation towards the outcome has to be greater than the thing that they're getting out of reward of doing something. However, our clients have the right to make those decisions in their own behalf. That's what balancing our duty of care and dignity of risk means. So MI stands for motivational interviewing. Listen to the client's point of view, the only one that matters here. Psychoeducation, be aware of the mental health and the dependency, the need, the fear that drives people, to have a look at all of those emotional responses that sit around that for our clients. Let's have a look at this list here. What can you see here that stands out for you? So when we talk about emotional quotient or emotional maturity, EQ, think about the things that we consider when we're looking and listening to somebody. If we listen to our emotions and the emotions in the language of our clients, anger can often mean, look into what you're afraid to lose. You sound angry about that. What are you worried about losing here? Could it be control? Could it be one of those things? I wonder what that is. And this is self-reflection for us and for our clients. Guilt, something's not aligning with your values. Fear, you're being challenged to grow or change out of this position that you're in or the position that you've taken or found yourself in. Shame, work on your sense of self-worth. Anxiety, learn to quieten your mind and find that base, regulate. Regret means there's an opportunity to change. I regret that. What would you like to change about that? Jealousy, acknowledge what your true desire is. Resentment, work on that victim mindset, that it's happened to you, that you have no control over that. Sadness, pay attention to what is missing. Someone presents to you, we refer to our psych ache. So on my notes, I will write all the details that I need to, and then I will put in what the psych ache is, what my observable things about their emotions are. So that psychoeducation is about having an understanding as what is that emotion? What might that be? We don't know. The only person who's going to be able to help us unpack that is the client themselves. But then if something triggers in you, reflect on your own responses in that space as well. This is where the ethical dilemma comes in. The law is easier to follow, but that ethical dilemma, why am I struggling in this space at the moment? So solutions for special needs, putting out a range of choices and then reaching an agreement together, but it really has to be the client's own goals. And then document in your records the decision the client made, not what you think will be good for the client. That would be unethical. Personal values and attitudes, we park ours at the door. The moment we're working with the client, we're actually working to the client's needs, their wants, if it's lawful for us to do so. So a client's own goals, and we'll refer to that as self-determination, dignity of risk. So everyone's entitled to their own values and attitudes. They should not interfere with how others are treated in the workplace. Somebody's different views should not discriminate or deny them access or fairness and equity. And it should be non-judgmental practice is a key to treating everyone with dignity and respect. We can write non-judgmental, and I'll be observing that when I'm looking at somebody's role play or reading their words. That'll be like, where is the non-judgment here? Where is the self-determination for the client? Where is the client's input into that. So when you get into your skills assessment, don't read it like a script. Have a think about, how would I engage with that person? What would be the natural flow of conversation? That compassionate inquiry, and then record what was said. The client stated, the client appeared to be. It's not a statement of fact. What we're saying there is what we think that looked like. So if somebody wasn't there, they could read our notes and they go, I'm getting an idea about what might have happened, but I'll talk to the client and what is it that they say from their perspective. Reflect on our own, so recognize the problem, evaluate options, find information, liaise and consult with colleagues and your supervisor if you're unclear and unsure, come to a decision and take the time to reflect before taking action. So a lot of workers will keep a reflection journal. You will do some reflection pieces as well when you're struggling. Some of your assessments will ask for you to do a reflection journal. What was happening for you while you were going through the scenario or the role plays? That's your reflection piece there. That one will be around, was there an ethical dilemma for you? It could be that you've not been exposed to that. So it could be the reflection that I found that a struggle, or I found that triggering, or I found that I was okay with that because I had a lived experience and I've had a lot of support, and I could see the value of a strength-based approach because I knew that that was helpful for me. So privacy of information and confidentiality is where our boundaries are. Boundaries are there for respect and safety. Session times, if somebody is booked in and you've got 45 minutes and they arrive 15 minutes late, all that means is that you've reduced the time that you can spend with them today. It doesn't mean that you're always running behind. It means that the time that you're there with your client is shortened by the time. And it's fine if someone says, look, I'm so sorry I'm late. It's not a problem. It just reduces the time. So today will be a shorter session. However, next week will take a little bit longer if you can get here. Is that a good time for you? Find out, first of all, whether there was something else happening for them that was competing with their time, rather than you're late, a statement of fact. Come at this around the boundaries. Are there exceptional circumstances? If not, then make your adjustments and put those professional, healthy boundaries in place. Can you take a gift from a client? No, you cannot. You could maybe accept a thank you card, but you definitely could not accept anything of any value. That would be an ethical dilemma. It would be a breach of the professional boundaries, because the only reason that you're in that relationship with that client is because of the employment that you are doing. Now, whether you are paid or unpaid as a volunteer, but you are still required to work inside those healthy professional boundaries. Your relationship is a professional one with the client. If you have a personal relationship with someone, that's a conflict of interest. You're ethically required to report that conflict and say, I can't work with this client, and let your supervisor and line manager know, because I have a personal relationship with them. That could mean a bias that I have towards them, known or unknown. But you must declare it. It's a requirement legally for you to do that, and ethically. So do not disclose any personal information. Be clear on your job role and responsibilities. If a client asks you to do something outside, so within the role that I have, that is not something that I can do. There could be other service providers who do that. Would you like me to help you find somebody? Your self-care. There's a time when we might share a story. If it's self-disclosure, where you're a peer worker and lived experience, it still needs to be not about your story, only if it's relevant and helpful to your client. So when we say, I understand what that feels like, I have experienced similar, but I don't know what it feels like, what you're going through. That sounds really hard. Professional debriefing. versus social debriefing. So professional debriefing covers all three areas of responsibility: your own, your organisation, and the client's. That's what professional debriefing and supervision is about. And if there's areas for improvement inside that. Social debriefing is unpacking your thoughts and your feelings, which is personal and not professional. And that's working outside of your boundaries. So a good formula in the workplace is 95% professional and 5% personal. And that's usually meet and greet and we'll see you next time. That's really what it is, not rushed. But the rest of the time, why we come together is because there's a professional relationship happening, even with our colleagues, making sure that we have very clear boundaries and they're consistent so people can trust and rely on you in that space. We need to make sure those boundaries are there to keep children safe and our most vulnerable target group. When it comes to mandatory reporting, which is a legal requirement, not only ethical, physical abuse, emotional abuse, sexual abuse, negligence, commercial or other exploitation resulting in actual or the potential for harm to a child's health, their survival, development and dignity, something that could impact them in the future. And that's under the World Health Organization, 2006, page 9 in that document there. Okay, move this around the board a little bit. Sorry, guys. So what are signs of abuse? Changes in behaviour and or how people present. Can be hygiene, can be some of those things. But it's your observables. The client presented in your notes. It appeared that, don't know for sure, but we're making that a file note, a record of fact, a reluctance to go home. What's happening there? Being seemingly accident prone, like injuries or attention that somebody is looking for. Excessive rocking or those self-soothing or the sensory areas there. And then showing wariness and distrust of certain adults or too trusting, difficulty sleeping and often being tired and falling asleep. That can be the overwhelm. Signs of abuse is inconsistent or unable to explain injuries, low self-esteem, bedwetting or soiling, aggressive or demanding behaviour, difficulty connecting with adults and peers, difficulty concentrating, being withdrawn or overly obedient, submissive, people-pleasing, creating stories, poems or artwork about abuse. These are the things that we need to look at. No one thing is enough, but it's capturing enough information to start to form an educated or informed opinion about something. So the duty of care is very clear around under 18 years of age with our clients. That's why we have a working with children check. All professionals have a duty of care around vulnerable young people in their care. Reporting is essential to stop the abuse and protect the child from further harm because they are a minor. The purpose of imposing a legal or other obligations to report is to enable an investigation and an assessment of fact. The protection of the child where necessary and the planning of long-term help and protection for the therapeutic frameworks around recovery for that child and their family. When we speak with somebody who is distressed or they're reporting, validate, listen, and believe that child. Explain to the child that you need to tell another grown-up, and you can never promise to be a secret. I need to make sure that you're safe. When we report, it is solely for the purpose of safety. Whether someone is at risk right now or there's a potential that they could be at risk so that it can be investigated further. That might be internally, but it'll be often based on your notes. Consult with the relevant line manager, your supervisor, your coordinator, your team leader. They'll have a higher level of responsibility and understanding of what meets that threshold. And then consult with family if appropriate. Then follow your organisation's policies and procedures, including the reporting and the documentation of those as well. Just remember, if you're consulting with family, that we're not placing our clients at greater risk. Make sure that you go up to your line manager around that and refer to your policies and procedures. And making your report, make sure that the details are there, the indicators of harm, the reason for reporting, safety assessment, which risk assessment, known and potentials, the description of the injury, the incident, what you observed, where that victim is or that younger vulnerable person is right now, and then other services that may need to know or do already know, and then what might be the family dynamics, and if there are any cultural considerations to make sure that we've got the correct representation there as well. So have a look at who would be the child protection groups. So in this case, agencies will change their names. I just want to flag that for you. When we have a change of government, often the name of the department might change. So make sure you've got the currency, whatever is correct for your state or territory, and those phone numbers. So that can change very quickly when we're writing our particular qualifications. They get registered with the Australian Quality Framework around the standards and around ASQA for the qualification. But during that period of time, those things can change. Make sure that when you're researching that you've got the links and the evidence to support it and reference those with the dates around that as well. So don't take something as that is it and that's how it always was. Even after COVID, things changed. As recent as 2023, a complete law added psychological safety into workplace health and safety in Queensland. So a lot of the brochures and the information around anything that we're working with in our policies and procedures, we need to make sure that we stay current with those as well. So that's ongoing for us. Always will be while you're working in the sector. So make sure that you know what those limitations are, your limitations as well, and then the limitations of the information you're working with. Only work to the scope of your role, and that will say in your position description what your role is. Even if I was in another position and I had different qualifications, I still have to follow that protocol if I've got a line manager. So go to your First Access site and refer to what the policies and procedures are in those, and then put them into your assessment work and apply that in the skills. So you can let a client know, this is what we do here at First Access. We have an obligation around this. I'm going to talk to you about the privacy and confidentiality so that you know that I can't talk about anything that we discuss here unless there's a risk to your safety. And that, of course, is priority. So inform your supervisor if you suspect it and report it. Then let the investigation take its course. Do not carry out any work or use any equipment outside of your skills and your knowledge. Any specialist training and qualifications are required for certain tasks. That means that we don't do it if we're not trained to do it, whether we think it looks easy or not. And whenever you are confronted with something you're unfamiliar with or you're unsure of, you must seek appropriate support. you must refer up. You must go and check the policies and procedures. And if you haven't interpreted them correctly, then you need to check with your line manager. So the legal and the ethical framework, they're two areas. One is must, and the other is where there can be some area that needs you to check that perhaps it is. So we can't bring in to this space our own views and opinions because we're in a professional setting. So it's the organisation's policies and procedures, which of course will be sitting underneath the legislation, and we must work to them at all times. There is no variation to that. It cannot be anybody asking us to do anything in the workplace that is against the policies and procedures. And if we see anything happening, then we must report that as well. That also is part of your responsibility. Okay, we'll wrap up. This is the end of this session. This unit, CHCLEG001. Thanks, everybody. Let's just go over and have a quick look at some of the assessment work that we've got here with this unit so that we can make sure that you've got everything that you need. I'll let you view. We'll have a look at some of the observation checklists for your skills, and then we'll also have a look at one of your written assessments as well. Great. Now let's have a look at the assessments that sit with this unit. CHC LEG001, work legally and ethically. I wanted to bring you over to the casework around these case studies. So there's 6 case studies as examples. So you're going to need to test your legal and ethical dilemmas that are sitting in here and which direction would you go. So let's have a look at what we're looking for with your written and assessment work, and then that will move over into your skills as well. So it gives you instructions. It says for this task, begin by reading the case studies and then provide detailed answers to the questions that follow. You must answer all the questions, so leave nothing blank, and their parts correctly to achieve a satisfactory outcome for this task, which means you're going to have to go back into the policies and the procedures into First Access. You'll have to do some research rather than guess this based on what you've got in your learner's guide or what we've spoken about in slides. That forms part of the understanding or the key learnings. But when we're talking legal, it's exact. So you need to go in and research and find out what's there. So with this first one here, with Juka is a community support worker, just for example. At First Access, that's our simulated space. He is supporting a 52-year-old person by the name of Zach, who has been working through challenges with addiction and mental illness. So they've got a dual diagnosis, so coexisting needs. Zach has had some serious health complications and is very unwell. When he received First Access accommodation, he had it recorded on his medical file that his ex-wife, Samantha, had medical power of attorney. If Zach ever reached a point when he could no longer make decisions about his own treatment, his capacity. Dr. Andreas is with Zach and Julka at the First Access accommodation, and Julka has called Zach's ex-wife, Samantha. When Samantha arrives, Dr. Andreas tells her that Zach has a particularly bad case of pneumonia, that he has not responded to antibiotics. Dr. Andreas, Samantha and Julka all know that Zach has also made it his wish to not pass away in hospital. Samantha makes the difficult decision and asks Dr. Andreas to no longer treat Zach, but to make him as comfortable as possible. Dr. Andreas agrees that this is what Zach wanted. Zach passes away quickly and with dignity. Trudy, a contact support worker who had supported Zach when Joka was unavailable, was heard to be saying in the staff room, "I can't believe the doctor didn't continue Zach's treatment. He would be alive now if the treatment was continued. Isn't that malpractice?" His ex-wife probably just wanted him gone. I have to report this doctor for malpractice and a breach of duty of care for Zach. Here, outline how Trudy has breached ethical and legal requirements of her role. Think about what boundary has Trudy crossed here. Explore that and enter your response. So this will be more than one sentence, but it won't be greater than a paragraph. So it says in detail. It also says describe a possible consequence that Zach has been given the antibiotics against the instructions of Samantha. What would happen then? And as you progress through with each of these case studies, save your answer and then move on to the next one. This one here is about a different case, which is Maria and Marcus. We've got one for Margot, Justin, Jovan, and Michelle. So this is going to test all aspects of the legal and ethical. You'll need to refer to which policy and procedure there may be a breach. Who can have that information? What steps were taken or should have been taken? What code of conduct may have been breached? Where was that conversation happening? Was that a professional setting? Did that person, within the scope of their role, have the right to have that discussion? And would you report that? What would be the step? So what happened? What do you think has been breached, if anything, here? And then why would you report that if you are going to report it? And what would need to have happen? Make sure that you've got 3 or 4 dot points in your responses. Don't just make it, this person just did this. It says detail because it'll have to demonstrate that you've got that underpinning knowledge, that you fully understand what legal or ethical policy and procedure or the act has been breached, if any, in that space. Go onto the First Access website and see where you can find that, where it's relevant to it, and complete task 2 of 4. Task 3 and task 4 are both role plays, and they'll have instructions, so that'll be your skills. For this one though, looking at this assessment, the one before this would be task 1. Task 1 will lead into task 2 and help you better understand this. And then, of course, task 3 and task 4 is demonstrating the skills in a simulated workplace environment where you are working with someone who is going to be playing the client, and you're going to apply all of those knowledge that you've gathered and all of those skills into that one scenario where we give you the story and you will be the worker and apply all of those steps that we've talked about in CHCLEG001. So this is really important. It's a core unit. It's also one of your foundational skills. It applies to every single person that we work with, every single peer and colleague in the workplace, and it applies to your relationship as an employee with your employer, a worker to your client, and a peer in the workplace. We'll wrap up. So we've talked about legal and ethical framework. We've covered the underpinning knowledge. You've got some additional resources and watched some recordings here, this one, and of course the resources that come with this one. You've got the slides, your learner's guide, and now you're going to attempt some of your assessment work. You can attend the study sessions, and then you'll be completing your skills component for this. So thank you, everybody.